Hi everyone. So we are entering the last module. Sorry, we are entering the last class on the IP module. We have a lot of modules to go yet. So today we are going to learn commercialization of IP. So far we've covered trademark search in the US and classification of trademarks in the US. We've also covered copyrights and how to serve DMCA notices. So today's class is about more on how to make money on your IP. And I believe we are going to cover character merchandising and influencer agreements, which is also based on trademarks and copyrights. So over to you, Dr. Anand.
Thank you, thank you. Um, in light of the previous sessions, we thought this is very important that if we can discuss commercialization of IP with you, and especially I think when we were discussing Priyanka and I think we thought influencer agreement for you budding influencers is required. So I hope the end of the class is like going to be like a banger, and I hope you enjoy it a lot. Yeah, next slide. What is commercialization of IP? IP commercialization is the process of turning an idea or innovation into a commercially viable product. Now, you would ask me, every IP is done with the idea of commercialization. That's not the case. Some IPR is just done for attribution purpose. Some IPR is done only for selling that particular product further, or maybe like patents and patents, whichever way they're done for purposes just for like adding something to the process. So when you look it into the aspect of economic reality or commercialization, this becomes very important. The most common method of monetizing creativity is through the selling of such a product or service. They stop competitors from exploiting protected characteristics illegally. One of the most famous thing that happens in Delhi High Court is trademark prosecution. They do a lot of passing of cases, and I kid you not that the number of cases before the IP division. How many of you know IP division in Delhi High Court? I think it's the first in the country as such. Are you aware? IP division is a special,
Please, please
huh?
elaborate.
Yeah, okay, that's great.
Yes.
Hmm? Okay, lovely. This is the first court in India who has set up a special bench or a special like roster wherein proper IPR matters are heard. It is currently being heard by two, three judges, and the most prominent judge is Justice Pratibha Singh, who is dealing with this aspect of IP division. And I kid you not, on a daily basis, people are going to the court and exercising these rights, making other people stop making these goods illegally, whether it be Louis Vuitton, whether it be your ghadi detergent, whether it be Kurkure, whether it be Pepsi, whether it be Rolex. All these brand names are spending a lot of money in protecting their brands and their images. So this commercialization becomes very important. Commercialization takes more than simply filling applications to protect and defend it. It depends on various internal and external factors. Now, what happens is that even when, for example, you have developed a new medicine, the chances are, if it's a path-breaking medicine and you belong to like a developing nation, chances are the government wants to compulsorily license your particular medicine. Okay, and the case in hand was during COVID. There was a huge consideration during that point of time. How many of us remember that? This entire aspect? Oh, that's lovely, Mansi. So it became so that, okay, so there was huge discussion with the fact that, your Covishield or Covaxin needs to be, specifically allowed to get compulsory license so that everyone can be provided for free. However, no country has done that because of the proper reasoning that everyone wants to exploit their IPR. Companies were earning money. I don't know if you remember, Aadhar Poonawalla was saying we are earning profits on making vaccine, but we are not attracting supra profits. Do you remember this? That he came on a television channel and he very candidly said, yes, of course we made money, but we did not make supra profits, right? Which goes on to show IPR as a intangible asset has a lot of value. Next case in point, commercialization of IP is Kingfisher Airlines. What Kingfisher did was their logo. Do you remember Kingfisher? I don't know if you've seen it on a beer bottle or the airlines or on the calendar, whichever way. Somewhere you must have seen it. Yeah, Kingfisher word. Yeah, as a small. And they had a like jingle also. I don't know how to say it right now, but I hope you remember that jingle, the famous jingle. Okay. Now what Vijay Mallya did, he valued his trademark Kingfisher as an intangible asset and took a loan on that. Now, would you suggest your client to do that ever? Like use your trademark and get a loan on that? As lawyers, would you do that? Suggest your client that why don't you like put your logo Nestle as a mortgage and like let's take money. But that was the idea that Vijay Mallya had, and now the banks are saying, boss, this is of no value to us. What will we do if the company is not only doing? Yes, correct, Shubham. And therefore, this idea of commercialization has its own risk. They include individual circumstances, business capabilities, competitive environment. Yeah, correct. Access to finance, the types of IP, usefulness of IP with regard to public utility, and the economic, social, and political environment. Now, what happens is that currently the brands which are suffering the most are, I'm so sorry to say this for you, but like the tobacco brands. Do you see recently three actors who were those famous actors promoting
Akshay Kumar,
tobacco?
Ajay Devgan, Shah Rukh Khan.
Correct. I didn't want to say the brand. Yeah, because then I'll be also promoting the brand. So therefore, in such cases, they are facing a lot of problem with respect to the public image, and a lot of people are doing a lot of litigation as well as they're spreading knowledge and awareness that how tobacco brands should be stopped in their forefront. Do you think such commercialization should be stopped where you don't get to see like even
Yes.
elaichis and whatnot? Yeah. Okay, most of you are writing yes. Others, Mansi and Mithun say yes, Sri writes yes. Okay. Okay. So basically anything copyright like Chetan Bhagat. Okay. Others are also writing yes, definitely. Okay. Harika writes it. Nikita writes it. Okay. Like Chetan Bhagat, what he did was he sells his books, whether it be Kai Poetry, whether it be 3D, they are made into movies. Is this commercialization of IP?
Yes.
Yeah. Yeah. So any aspect of IPR, any right that you hold, you can exploit it commercially as such. That is the crux of commercialization of IP. Now let me read further. Next slide. Now there can be of three sorts commercialization. Commercialization by owners. The proprietor, whether an individual or firm, can pursue their goal of commercializing their own intellectual property on their own. Commercialization by assignment. The term assignment simply refers to the transfer of intellectual property from one business to another through a direct transaction. This can be done for a set amount of money, which includes all costs associated with the purchase and protection of IP, any R&D cost, any outsourcing cost, and so on. Commercialization by business partnership. This includes methods such as licensing, franchising, joint ventures, and spin-off and other business contracts. Now let me divide it for you. Commercialization by owners is very simple. Let's say the brand, give me a name of a brand that you want me to explain. Let's say, let me take a random person. Let's say Zara. Okay, Zeba. Let me take Zara. Now, Zara trademark and entire product line is owned by a European company. Okay, the company who owns this has all the rights to exploit Zara the way they want to. Okay, why so? Because they're the owner of the trademark. Okay, now if you remember last time when we were checking trademark search, let us do that again. Mm, okay, Mehul, that's the name, right? Could you just, yeah, again do that? Can you just put tmsearch.uspto.gov? Just, yeah,
What do I need to do?
just erase
Just
everything
click
else
on the
except,
trade.
uh,
Yeah. No, click on the
uh,
trademark icon on your left.
okay, let me
The
give you
violet one. On your left.
Yeah,
a second. Thank you. You did that. Okay, let's go to basic word mark. Basic word mark search. Select a search option, Mehul. Mehul, सामने. हाँ. Okay, let's type Zara here. Okay, now see here. Okay, who suggested Zara? Zeba. Okay, so Zeba suggested us to take Zara. Now, can you see the number of word marks that have been registered for Zara? Can you all see that? Now, should Zara be concerned? As lawyers, would you suggest Zara to be concerned? Or is it okay?
It's too much.
Too many? Yeah, okay. It's okay. Zeba is like, okay. Now, the fact is, as I told you last time also, they are for different classes and different marks. Yes, exactly. So, therefore, there is no problem. But if anyone tries to even enter into the clothing range, that's when they have problem, right? So the ownership tries to protect it by that method properly. Trademark assignment, or let's go back. Mehu, just keep this as it is and let's go back to, yeah, the slide. Correct, Mansi, clothing or accessories. Now, for example, if one day they enter into, let's say, this agreement with your sporting attire, what do you call it? Is it workout gear or whatever you call it? Okay, Anshu, were you saying something?
No, no, it's for gym clocks and
Whatever, yeah, whatever. So basically, they can get themselves registered in that category as well. Also, okay, commercialization by assignment. Assignment is a very simple agreement. You are a right holder, I assign you to become a right holder. Let's say I am the right holder to uh, let's say a brand called Waterman. You know those Waterman pens or Waterman fountain pen? I don't know if you have seen it or not, huh? Now for example, I take Smita as an assignee. Okay, now, what will happen is that Smita wants that she requires this trademark to exploit it and she wants an assignment agreement. Now, since I'm the right holder of Waterman and Smita is the one who's the recipient, there will be an assignment agreement signed between me and Smita saying that she can exploit it, she can utilize it, but she will not be the right holder. Just like how you remember your lease and license, right? Even if you're a leaseholder, you're not an owner, right? Yeah, in your normal property law, you have read this, right? You can assign your rights, but you will not come to own them. Are you all understanding it? Okay. Shubham is saying, but sir, last time you said that if they are super popular, they won't let you enter by the name even in different class. Now this is what they try to like literally fight over it. But what happens is that Shubham, they will get access to certain classes until unless it does not create confusion and there is no deceptive similarity. There is no bar, but if their business is getting affected, they will come behind you. If Zara is registered in some other category which is not even remotely connected, let's say they do it in hardware mark, they won't care for so much. But if you do it in like something which is ancillary to clothes, let's say your zips and so on and so forth. Yes, exactly. They have to be a different product category altogether, Shubham. That's correct. So commercialization by assignment becomes easier because of the fact that you transfer your rights. This biggest example is the fact that footballers or cricketers, what they do, they have something called as image rights. Okay. Now you must be knowing there are many restaurants that cricketers and footballers have. Can you name a few? Any restaurants? Yeah, 1-8. Okay. Sorrows by Saurav Ganguly. Okay. Others? Restaurants by cricketers or footballers. For example, the one that Cristiano Ronaldo opened in Portugal, he gave his trademark CR7 to that particular, agency or to that particular chain of hotels. So basically, assignment can happen. Like Saurav Ganguly can, give his name Saurav. Even for that matter, Virat Kohli has a few restaurants, and all these cricketers own a lot of restaurants. Sachin Tendulkar and whatnot, whatnot. Tendulkar's exactly I was coming to that. So this assignment is very important. Okay. So if you do not want to exploit it yourself, you can give your trademark to someone else and they can exploit it on their behalf. Commercialization by business partnership. This includes methods such as licensing, franchising, joint venture. I can't read Mehul. Yeah, thank you. Joint ventures and spin-off. McDonald's. Do you remember McDonald's? Vikram Bakshi dispute? No, no, it is not Ayman. Yeah, the Vikram Bakshi dispute, where Vikram Bakshi also owned certain amount of McDonald restaurants. Then they had a huge dispute going on whether, like, how should we look at it. Then finally it was decided that Vikram Bakshi will sell off his, set of McDonald's hotels, restaurants, sorry. And the same is the case in Russia. A Russian oligarch basically owns 15 to 25% of Burger King restaurants. Burger King has officially left Russia, but this oligarch is not shutting them down. Why? Because he has a business partnership and he is utilizing that. Is it right? Do you think? Should Burger King take any action? What would you suggest? Should Burger King take action against that Russian oligarch? Yeah? Okay. Others? What is everyone's view? I see a lot of students today. Yeah. Okay. We should take an action against the Russian oligarch. Okay. If license is there, of course there is business partnership, Anshu. So the Russian oligarch is saying, then, like, they pay a license fee or a franchisee fee every year. I don't know, they possess substantial amount of shares, but like they have 25% and they own franchisees for, like, let's say the next 5-10 years.
No, they can't.
They're saying we don't. Huh? Okay, so then no. So therefore, franchisee agreements also become very interesting. Only action can be taken if conditions of licensing is infringed, right? And I don't know how many of you remember your contract law, but in contract law, this age-old principle was there that if you sign a contract with enemy country, do you remember that? If there is an agreement with an enemy country, then it does not become enforceable
Yeah, at times of war, yes, sir.
at times of
It
war.
was a
So can we
treaty of
consider
election,
this?
I guess, in Germany.
Yeah, yeah, very good. Can we consider this as a state of war and can we deny contractual enforcement?
Yes, sir.
Yeah, we can make a
Yes,
case
yes, yes.
for this. Okay, but still they couldn't because of the fact that the contract was made this way, and plus US has not declared war on Russia till now. So therefore, that oligarch is really counting on that. Yeah. Okay. Let's go to the next slide. Any question with respect to this slide?
Yes, one, sir.
Ah. Hmm.
Yeah. So, as you said, at times of war, can these principle be little more extended and like many things evolve with time? Let's just say this principle evolves in a form that any country which makes any sort of damage or any sort of threat against any company, will this principle be also applied then also?
Like for example, I'll tell you if there is an agreement between Atif Aslam and India that is now no longer in play. Okay, let's say T Series has a 10 movie contract with Atif Aslam. Post government declaring that we do not have any proper relations with Pakistan, that contract will be voided.
Okay, sir.
So any sort of assignment agreement or any sort of music transfer that has happened, then it becomes problem. Does that help?
Yes, sir. So, to for these contract to be void, we need any sort of government notification regarding.
Yeah, yeah. You need a declaration of war or declaration of enemy
Okay,
country.
thank you.
Yeah. Okay. Next slide. Example of commercialization, first market advantage, first mover advantage, eBay, Kleenex, and Amazon, or the Moki doorstep. If you see, this is very famous. It came on Shark Tank, not Indian, the American Shark Tank. This Moki doorstep that you can latch it on your U-shaped latch on the car, and you can go even to the rooftop and place your equipment there. Have you seen this episode by any chance or this clip? Anyone? No? And can opening system be patented by Coca-Cola? Okay. Now, fact of the matter is, a lot of this was, you know, previously protected under IPR regime, but then it became so common. Like, can you imagine opening a can in some other way? You remember, right? The frozen food that would come, and there was a can opener that would come for solid foods. It still comes, right? I think there are pineapples and I don't know what all that still comes in cans. Any example of cans? Not your like Coke cans or beer cans, but like yeah, frozen beans. Okay, that's a great example. Baked beans. Okay, lovely. So commercialization, even if it exists, cat food. Okay, brilliant. Okay, rasgulla. Thanks, Sri. Just suddenly started feeling hungry. So this becomes very interesting as such. How commercialization can take place. All these exploitations are done by agreements, and that is why your IPR become very important. So car seat belts are invented by Volvo, but it is for safety, so they didn't file for the patent. Now, what happens, Shubham, if today I invent something like an airbag? This would become industry standard, and it would become a standard essential patent. Just like how I give you example of those mobile chips, your Wi-Fi 4G chips, they're a standard essential patent. If someone has developed it, then you can't go above and beyond, right? Like, yeah. So that's the example of commercialization. Like, let's say others also. Can you give examples of commercialization that you say on day-to-day basis? Other good examples that we are missing out on? Let's say of copyright, Xerox. Okay, okay. It's a very good practice that it's a suggestive name that it is like you're suggesting that you're Xeroxing as well as this particular thing. Uh, the biggest thing was real Jews. Real Jews also took a lot of heat for saying that they are the real Jews. Yeah, have you heard of this dispute? Real Jews saying that we are real. Gas stoves and induction stoves. Yeah, correct. Absolutely, Harika. So commercialization also, and especially, you can't say Wix, okay? You can't say you're number one, like, doctors recommended, dentists recommended. Why? Because recommended can be two people. Like, for example, me and Suchi can recommend that this brand given by Jacinta is the best brand, right? So that's a recommendation given by set of people. Therefore, you can't add these qualifications such as best brand, number one brand, because all these Surf Excel and like Dettol used to do a lot of this business. Then the government came hard on them, saying, no, no, no. If you do this, then there is problem, right? Okay, let's go to the next slide. WIPO's notes on IP commercialization. IP commercialization is making money out of one's idea. An idea has no value until one makes it into tangible object, and its utility has been proven such that the others would pay to use, see, read, recognize, or listen to that product. We define the commercialization of IP as a continuum of activities and action that provide for the protection, management, evaluation, development, and value creation of ideas, inventions, and innovations to implement them in practice. The commercialization of research results and related IPR by research universities involve a compilation of activities including education, research and development, entrepreneurship and innovation, and the development of experience and expertise. The benefit of commercialization are shared throughout the ecosystem, ranging from the universities and research institutions where these discoveries are made to the industry and development partners, the supporting organizations, the legislators, and of course, the people whose lives are changed by these improvements. Now, this WIPO's note on IP commercialization, let me show you with an example. The first one, Mehul, please share this. The first example that I would like to take is of the famous logo that Roger Federer had, right? How many of you remember that logo, RF? Yeah, RF, Roger Federer. Do you know this tennis player? Yeah, no? Should I show you the logo? Have you seen the logo? At least say yes or no. Yes, okay. No, okay, let me show you the logo. One second, guys. I'm just like utilizing the okay, I'm sharing it in the chat. Can you all see the logo? Can you all access it? I have shared it in the chat. This RF logo, there's this tennis player called Roger Federer. What he did is just like, do you know Air Jordans by any chance? Air Jordans? No? Yes, some are saying yes. Nike, correct. Let me show the Jordan logo as well. One second. You guys have really not seen the Jordan logo? Okay, okay. Still, I'm sharing it for all those who haven't seen it. Why? Because IP can only be understood by example. It's not some theoretical exercise that I can explain you. But like, yeah, okay. Could you show it, Mehul? I think it will be better if everyone sees it
The
on your
logo
screen.
that you sent,
Just right now.
just
That's
give me a
right,
moment.
brother. Mehul, could you just share that, open that thing?
Is it visible? RF.
No. Jordan. Guys, if you have seen it, do you want me to share it still?
Okay,
Or
okay.
how
Just
many of
give
you
me a
have
moment.
not seen it?
I need to change the screen.
You have?
Uh,
Okay. Okay, this is the Roger Federer logo. Okay, RF is Roger Federer. This logo was owned by Nike. Okay, now in 2018 or 2016, I think Roger Federer changed his t-shirt ambassador or t-shirt, branding from Nike to Uniqlo. Now, for the longest time, Roger Federer said, "I want my RF logo back." But due to the existing commitment that Roger Federer had with Nike, he was not allowed to exploit his trademark as such, his image rights. Only in 2020 he got access of this logo. Now this is very important in commercial sense because I don't know how many of you follow football, but whenever a player transfer happens, now some of the clubs own the image rights, and that's why the player transfer becomes a problem. Why? Because image rights are everything these days. Transfer is, of course, Mithun, but like image rights become a huge problem. Why? Because let's say CR7, MSD7, SR10. Okay, are you following all these brands? All these players? Virat Kohli, his brands or all these brands, they become hugely important for discussion. And if you see, that is why people create attractive logos. Mehul, could you show them the Jordan logo also? Sir, did he buy it or got in completion of the contract? Shubham, I think he raised a dispute and then he finally got the logo as a one-time settlement that he did with the company. How many of us have seen this logo? Yes? Who is the player in question? Who is this famous basketball player? Yes, Michael Jordan. Very good. Everyone, okay. Michael Jordan till date earns millions, and I say millions of money just for this logo. In one of the famous basketball finals, conference finals, okay, Michael Jordan actually had this photo where he jumped this much for dunking the ball, and this image was used on back of his shoes. This was the first time anyone ever exploited the image rights this way. That he's a basketball player, he has a ball in his hand, and it became a trademark logo. Air Jordans are now the most costliest pair of shoes that you can wear in sports category. Michael Jordan gets around like the total revenue he has got from this particular Jordan sale is above $300 million. You see how commercialization has happened. Now they've become iconic. Now they have become somewhere very essential for all those who play basketball, tennis players, cricket players, football players. That is how they have specialized themselves. So the WIPO note talks about this really, how commercialization can take place. Right? Do you understand? Can I go back to the slides? Any query on how commercialization happens? Yeah, I'll be happy to help if there is any query. None. Yes. Next slide. Now, character merchandising. In character merchandising, the popularity of imaginary character, it's right still with Nike as Mansi. There is. Our celebrities is being exploited. You're asking Jordan's right or Roger Federer. For example, garment, glasses, purses, and other items with image of a fictional character of a celebrity. Jordan still exists. How many of you have seen Minions? Those soft toys, Minion? Yeah, you know what are Minions? Or for example, even your Donald Ducks and your Mickey Mouse. Yeah, we have seen so many examples. Despicable, exactly. McDonald toys for the longest did a lot of character merchandising for so many companies. I don't know how many of you remember all cartoons used to feature like in character merchandising, and like I don't know if like I don't know if anyone has been to the Disney World or let's say your Universal Studios. There they sell a lot of these products. Like for example, uh, even Jurassic Park, those dinosaurs that they sell, or let's say any other famous movie. Uh, yeah, let me show you that. Okay, Star Wars. How many of you know Star Wars? Can I show you Star Wars example? I think it's a all generational example that I can show you. Okay, one second. Mehul, be ready to share. First, let me show you example of how George Lucas was way ahead of his time. George Lucas patented something called as the magnetical sphere balancing robot drive. Can you tell me what is the name of this product? All those who have seen Star Wars? Mind you, George Lucas patented this, and you can see assigned to Disney Enterprises. Application filed in 2010, granted in 2019. Any idea which is the character I am talking about? The character name is BB-8. Have you seen? No, Zeba, BB-8. Yeah. So BB-8. Do you know BB-8? That droid who would keep moving all the time and has this. Yeah, all of you know that. Also, lightsabers. They filed a patent or a patent for getting lightsabers done. This is all character merchandising, by the way. Okay. Also, let me show you uh, other examples. Let's go to the Mehul. Could you open? Yeah, Lego has these, correct? Can you open the trademark search one that I told you? Please keep it open. Yeah, record. Next picture la record. Hmm. Yes. Now let us search. Go back. Hmm. Now go on search. Why I'm showing you this is how merchandising is done. Okay, search trademarks. Correct. Absolutely, Harika. That's a good example. Yes, search our trademark test. Yeah. Please put in Star Wars here in basic word mark. Okay. Star Wars Eclipse. Star Wars Rogue Squad. Star Wars The Acolyte. Now, how many of you know the most famous Star Wars slogan? May the Force be with you. Yeah? Let us see if May the Force be with you is a registered trademark or not. Can we go back and check? May the Force be with you. These are all registered marks, by the way. Mehul,
What do
Go back.
slides
No.
do?
Search again. May the force be with you.
Okay.
That's correct, Zeba. That's why I took a intergenerational example. Everyone knows Star Wars
Uh,
properly. Can we go back to search?
Define research or
No, go back. Yeah. Again, go to test. Yeah. Yeah. Search. Okay. Please. Write me the force be with you. May the force.
what do I need to write?
May
May
May the force. That's it. Search. Correct the word. Okay. Can you see the trademark of the logo? Yeah, of the word itself. May the force be with you. Are you seeing how character merchandising is done? All Jedi's would say, "May the force be with you." Or if you're seeing Mandalorian, those small, what is it, Grogu or the Mandalorian images, that's how you conventionally exploit it. Even for Donald Duck and Mickey Mouse, you must have seen Mickey Mouse everywhere, right? Or Donald Duck, or He-Man, or Shinchan, or Chota Bheem. All these are character merchandising. This is exploitation of IPR. Any example that you have in your mind for character exploitation that we haven't covered? Harry Potter. Oh, sorry, Zeba. I'm so sorry. Harry Potter is the biggest exploiter of merchandising. How many of you have ever purchased that wand or those glasses? Has anyone? Zeba, I figured that much. Anyone else? Harry Potter? Guys, are you following how character merchandising can happen? Priyanka has, I feel.
Oh, no, I've done something crazier. I've sent a letter to Hogwarts to my sister from the merchandising shop.
Very good.
And to be very fair, they also have the stamp of Hogwarts, the seal, that is made of wax that you
Yeah.
can put in the
Yeah.
letter.
Yeah.
And everything, the calligraphy, everything is under their IP.
Correct.
Even
And
their paper is, I think, protected.
no, but yeah, like they make it that way that it looks like that. So
Yeah.
clearly, let's go back to slides. That's a great example, Priyanka. But you must have spent a lot of pounds doing that, by the way.
Let's not talk about that.
Okay, fair enough. Okay, so Popoy and all these characters, you have a lot of T-shirts that you wear. Let's say, what is that? A new movie that came, Pushpa. Have you seen Pushpa? What is that movie name? I'm forgetting. Is the name Pushpa only? Yeah. Okay. There are such famous steps that he does and like all that things. If he wants, he can register this and exploit it. Okay. Like let's say, I'm just giving you an example. Let's say if Shah Rukh Khan wants to go Spider-Man, correct? Spider-Man t-shirts, Marvel, the entire Marvel universe, they get a lot of money through merchandising. Spider-Man, Iron Man, Hulk, Wonder Woman, uh, Black Spider, so many, things that they exploit. Game of Thrones. Now you are coming to the party, everyone. Even the Gauntlet, correct? Lord of the Rings, Barbie doll dress, very good examples. So you're getting to the character merchandising thing. This is important. Why? Because when you are giving those rights, please ensure if you're a creative person who's dealing with a lot of development and all such things, please ensure you have these rights. And when Star Wars was being made, George Lucas said, please keep the merchandising to me. Rest, you can give me less money. Star Wars is the biggest example because by 2030, George Lucas would have earned $30.8 billion only through merchandising. Can you imagine? Darth Vader, lightsabers, Jedi, Anakin Skywalker, all so many, characters that they've exploited. Even Pinocchio, Zuzu. I don't know any Indian example that I can give except Chota Bheem for character merchandising that they do, where there is proper IP protection. Any example? Doraemon is not India. Shaktiman, okay, great. Krish, lovely. Motu Patlu, okay. So Shaktiman, okay, very good. So of course they can also do a lot of, I don't know whether we can call it IPR by the way, Harika. So that's why I have issue like whether we can exactly say that like yeah, Junior G, okay. So there are a lot of examples that we can say for okay, Krish. Someone is saying again Chacha Chaudhary. Is Chacha Chaudhary like made into something else except comics? Mowgli, although they say Jungle Book is not art. Okay, next. Some prominent merchandises in UK. Warner Brothers have this entire Batman thing going on for them. Warner Brothers owns all the IP rights in Batman, including the design on the Batmobile. Mark Toll is the owner of the car building shop called Gotham Garage. He manufactured many cars which were identical to Warner Brothers Batmobile. Warner Brothers filed the case against Mark Toll for infringement of copyright. What do you think? Would he have won? You know the Batmobile, right? Famous. All Batman travel only in that. Have you seen Batman? Or is this example again lost on you? Yeah? Okay. Okay. So Batmobile, they lost uh, the case. The garage holder and Warner Brothers won it because they showed it's an essential to the entire Batman sphere and like how they cannot exploit this as such. So therefore, like the entire thing became such a discussion because the fact that this proper prominent merchandising becomes an issue. The other example that I can give you is that of do you know this famous footballer Messi? If you have heard of his name, Messi, Lionel Messi, yeah. So he had he has the biggest trademark portfolio in when it comes to a celebrity or a footballer. Now he had an issue. Kit cars, as they called in the industry, they do not get sued much as they are replicas of many cars, correct? But Shubham, what happened was he was portraying it as their Batmobiles. That's why he got into a dispute with Warner Brothers because they're like, we never gave him any rights to exploit. Anyone can make it this way. Even like if you assemble a car or if you draw, design a car, you can do that. But like when you're doing commercial exploitation, then you need rights as such. That's what he did not do. Yeah. Now, the problem that was coming was that there was this trademark that Messi wanted to register, but there was already a same name called Masi, Massi, and they said like whether Messi should given the rights or not. Prominent merchandising. Do you think Messi should get a right over Masi? There is a restaurant by that name. Do you think it creates deceptive similarity? All those who practice in trademark, do you think it does that? Deceptive similarity? Do you think
Yes,
there's,
sir.
yeah? Okay. Many of you said yes. Okay. So, of course, Lionel Messi won the dispute because the court said, listen, there is no one bigger than Lionel Messi. and he should be given trademark rights. So the merchandising aspect, even in the Batman mobile case, they gave him to this right because of the reason that Warner Brothers has made it sure that this is the brand and the image that they are trying to create, and they don't want to give it up. Okay, next slide. Next slide. Okay, issue whether Warner Brothers can prohibit Mark Toll from copying the automobile design of Batmobile. Decision: the court held that the Warner Brothers enjoy the rights in the character of Batman, and there is an infringement of the derivative works by Mark Toll. Reasoning: the court relied on character delineation test. This test focused on the distinctiveness and significance of the character in a show or film. Without the presence of that character, the story cannot be told. Such characters are entitled to copyright protection. For example, Rocky Balboa, the story cannot be conveyed to the audience without the presence of the character Godzilla in Godzilla, right? So, do you get this example? Rocky Balboa, if Rocky Balboa is not there, or let's say in what was that movie? Indiana Jones is not there. Yeah. Do you think, or all these 007 movies, if James Bond is not there, can you say that the character, there is delineation or not? Can you divide it? Can you differentiate it? No, right? So the rights will always exist in the character. This is what the entire discussion is on merchandising. I know for you it might be a little different or a difficult way to understand because not a lot of you must have ever seen it. But all those who are in working in, let's say, Star and Hotstar, or let's say Viacom, you see all these agreements being signed every day. How, let's say, what is that movie? Ranbir Alia movie that's coming up. I'm forgetting the name. That what's Ayan Mukherjee made? Brahmastra. Okay. For example, this is this new superhero movie that is being said in India. Okay, they can actually get merchandising all in their favor, and anyone who wishes to utilize all these names, trademarks, will have to then go. That is why Yash Raj and Dharma, all these people have a lot of merchandising and like these trademark teams that are constantly dealing with agreements. Okay, that is why we are doing this, and it's important. Next.
I have a question, sir.
Yes,
When
Mithun, please.
when we have to register before the movie release or
Before.
before it? Okay,
And actually, the best idea is before you actively take out a trailer also.
okay,
During
sir.
development stage, get those trademarks done. Let me show you merchandising copy. Okay,
Okay,
click
sir.
on the link.
Sir, even I have a question. Can I?
Yes, Nikita. Please.
You were just mentioning about, you were asking questions about Indian reference, and I have this one question. I don't know if it comes to character merchandising or not. There's this very famous Shiva statue, bust statue, which is a statue is in Isha Foundation, if I'm not wrong, which was not there earlier, but from some time it has been now. We see it every shops. So can that also come under character merchandising?
I'm not too sure of the arrangement, but if they are exploiting the rights in some way and they're saying we are selling it and it is considered as a part of their IPR profile, then yes. But if it's
So
not part of their IPR profile, I'm not too sure what is the agreement basis between them.
So the confusion that I have specifically to this is, for example, you were mentioning about these specific items in the movies or the shows, right?
Yeah,
But
yeah,
what if
yeah.
there's a popular figure like Shiva is a popular figure already in India? We can't put a IPR statue over it, right? So in that condition, can we can a organization say Isha Foundation is saying that no, only we can say,
No,
sell
they
this
can't.
statue or not?
No, they can't. You don't have rights over God. For example, I create Last Supper again. I can't say I have trademark or I have copyright over that because ultimately you're depicting an image of a god. In that, you don't have rights. Correct. Mansi gives a good example, Nikita. For Buddha statues,
Yeah.
also, you can't do anything. Like, for example, if there is a retreat which sells like a proper, meditation resort, they can't start selling Buddha as their IPR. No novelty. Correct.
Okay.
So, no one can trademark or copyright gods because we don't have any rights.
Okay. Even if they come with this special distinction that we have seen during this Isha
Yeah,
Foundation statues, even
yeah,
then.
like even then, because of there are problems with respect to that. Because of the fact that when you depict deities in any other way, it might also hurt religious sentiments. So
Okay.
gods cannot be owned that way, right?
Right. Right. Okay.
Okay.
Thank you, Mike.
Now Warner Brothers, showing, yeah, this is this agreement for theme park license, and this is your famous Harry Potter, I think, studio that they are making, and they have referred to books and authors agreement. So this is the definition clause. The license agreement is made in 2007 between Warner Brothers, Delaware Incorporated Company, and UCD Partners, a Florida limited partnership. Let's go further. Let's see. और नीचे तो सब all these are definition guide. Okay. नीचे नीचे. Yes. Okay. एक सेकेंड ऊपर थोड़ा ऊपर 3.1 से license and other rights subject to restrictions, limitations, reservation and commission, and licenses approvers rights set forth in agreement. Licensor hereby grants to licensee, and licensee hereby accepts for this term of this agreement a license to utilize the licensed property solely in connection with development, construction, and operation of the themed area and the license use. Now you understand what I was talking about, assignments and licenses that you are giving. You are giving them exact reason and exact detail. Okay. Now they are also mentioning the term. Initial term means from the date of complete signing of this agreement through and including 30th June 2019, provided that at the time of each renewal, licensee is not in material default. So they've given approvals. Licensee shall at times and respect maintain the general appearance, maintenance, staffing, and overall quality of the theme park. Now they might have got the rights by Warner Brothers, but they have to assure that the quality is maintained. Licensee shall use licensed property only in the matter that is consistent, guys, with brand guidelines and with the goodwill and legal rights of licensor in the licensed property. This is why we wanted to show you this agreement. Go further. Licensee shall not initiate any use of the licensed property hereunder unless such is first approved. Now approvals are also required, and then there is this one clause. Yes, licensee shall submit a written request to licensor specifying each specific license use that it wishes to make of the licensed property. And now they have given example: two-dimensional license product, three-dimensional license product, food and beverages, rides and attraction, print media. 5 particular way. Could you scroll down थोड़ा सा नीचे और 3.6 पूरा आ जाए? Even एक मेहुल आराम से 3.6 दिखा मेरे को. हाँ, yes. Television and internet advertising, radio or other media, and all other license uses. So they have identified at least 7-8 ways of exploitation of the licensor rights. Any question till now how they're doing this? Any clarification that you want? Anyone? You're all following this, right? What exactly this is? Warner Brothers is giving rights to this theme park, but they are saying, please take all these approvals from us. two-dimensional, let's say rough sketches, finished artwork, or final proof. In 3D, they're talking about action figures and clay sculpts and all that, food and beverages, rides. I don't know if you have been to Universal Studio in Singapore. What they do is they have special rides. Even Priyanka would affirm, even in the Harry Potter, world, they have these rides, special rides, where you would feel as if like you're in that car of Chambers of Secrets, and like on that Hogwarts train. There are so many experiences that they are trying to create, right? Isn't it, Priyanka?
Yeah, too many. So they also have a cafe where they serve butter beer basically.
Oh yeah,
So
yeah, yeah, correct.
just a butterscotch soda, but then that is exclusively sold only in that cafe. And to elaborate just a little bit, Warner Brothers don't give permissions outside of UK mostly. Now recently they have started spreading their merchandising assignments, but I think till 2016 they were not giving licenses also even outside of UK.
That's also to do with the reason that Disney and all other Universal Studios have become so popular as theme parks, and America is the biggest consumer of theme park market. So they realize this is such a huge opportunity to like capture one of the most prime estate that is in Florida. And if you make something in Florida, they are considered as huge heavens for like spring breaks and like winter breaks or Memorial Weekend or 4th July weekends and whatnot. So Thanksgiving also, many people celebrate in a lot of theme parks these days. So it has become a huge consumer attraction these days now. Let's scroll further. Okay, come to clause 4. Go further. Hmm. Okay, conditions, limitations, and restrictions. Now read this. Use of the licensed property is limited to the licensed users. Approved users. In assignment, you are getting uses. What all way can you exploit, guys? This is very important. As an IPR lawyer, as an international business law reader, you need to understand these uses as such. And other uses that have been approved in writing by licensor, they have also communicated the method in accordance with the terms of this agreement, and all rights in to or associated with any and all other uses are excluded from this license. Moreover, all uses in to or associated with the licensed property, including without limitation, the following elements are included in the license only to the extent specifically approved in writing by licensor, and then only to the extent rights in and to such uses and elements are owned and or controlled by the licensor. This is the best way you limit uses. If ever in any job interview or in court they ever ask you how do you limit the use, this is the example. They have given you rights, but they have limited everything. So if you ever encroach this limit, they will take action against you. And let us see what all regulations have they put on things. Film clips, live action or computer generated still sound bites, voices, music, or other audio clips. The names, likenesses, autographs, signatures, visual representation, audio recording, or voice of any and all actor, authors, creator, director, individuals represented in or otherwise attached to or connected with the licensed property. For example, uh, your example of let's say Jack Sparrow, and Jack Sparrow, right? I don't want to go into the legal dispute that they are currently facing, but just as a character. Yeah. Okay. Very good. So Jack Sparrow is very famous with Pirates of the Caribbean. His voice and his particular action and how he looks, how he builds himself, are all part of these limitations and restrictions. You cannot misuse these rights. How many of us have seen The Lion King? The Lion King, yeah. The entire theme is shown in some of the theme parks. There are people who sing the entire Lion King song. Yeah, if you notice the first scene that they show of the entire South African jungle where everyone is there. I don't know South African or Kenyan, but like the entire song exists between them, right? Yeah. So that's that. Correct. In alien. That's correct, Deepak. Uh, let's go further. If I can show you warranties very quickly. Now, consumer license products, you have understood the theme. Can you show me warranties by any chance? Consideration, they have already given you what are the consideration. You can read this in your free time. This is easy. Let me statement and payments. That's okay. Go further. I'm trying to show you clauses which will be difficult. Use and ownership. Okay. Clause 8. They have defined licensee covenants and agrees that as between licensee and licensor retains all rights, title, interest, and copyright in and to the licensed property. Now, do you follow what I was telling you in assignment? And I was telling you that, for example, if I give my rights to, let's say, Smita, okay, in that case, I'm not selling off my rights. I'm just giving her to utilize these rights. Or let's say to Nikita, if I give these rights, and even to Sneha, if I give these rights, and to Mithun, I can give these rights in different jurisdiction to them. Let's say I give these rights for India to one person, US to the other person, UK to the other person. I can exactly do that on a territorial basis. But I'm not selling them my IPR. The IPR retains in me. And that is the problem that Top Gun is facing right now. Let's go back to the slides quickly. I think I will show you this merchandising agreement again. Yeah, let's go to the next one. Important clauses. Types of merchandise to be maintained, distribution network of the license, royalty, maintenance of quality standard, license to use trademark, right to privacy, infringement, concerns of the licensee, exclusive rights, duration of the license, territorial scope. This is what I was telling. I can give Nikita, for example, India's license. I can give Sneha the license for UK, Mithun for US, to Smita for the entire, South American region. So I can differentiate this and termination clauses for celebrity statements. These are the most important clauses now because you can't make any unsolicited statements these days. And this is the reason why Florida is having a lot of issues also right now with Disney, because Disney has an inclusive hiring policy, and Florida just passed this bill that you cannot openly mention the fact that you are from a minority community, not as in uh, what we understand in India, but sexual minority. So there are problems going on in the Disney park right now, but let's see what happens. Next, influencer agreement. How many of us are influencers here? How many of you have danced on all those random numbers, Kacha Badam and all? Or if you, yeah, Anshu, that's lovely.
Yeah,
How many of us are influencers? Priyanka, you also are? No, Anshu, you are saying, okay, Anshu, you have, okay. Anyone else who's an influencer here? Who does a lot of Instagram work or LinkedIn or Facebook, YouTuber? Oh, that's lovely, really. So, influencer agreement in this modern era is the most important thing. Sports YouTube, Mithun. Oh, that's lovely. That's great. So, let me inform all of you, all lawyers, practicing lawyers, transactional lawyers, corporate lawyers, why this is important. Everyone is now exploiting. Indians have a huge market. Insta Reels are the most uh, Indian oriented thing you will find. Why? Because TikTok is TikTok banned in India? Why is TikTok banned? And this will give you answer of the IPR question as well. Someone was asking this query, no? About the enemy country. India effectively took out a notice saying we will not allow you to transact with China, and they banned certain apps. Correct. Just like how China bans a lot of apps, Indian apps. So now the only place where you can make your content is on Instagram and Snapchat. Insta Reels, as much as they are irritating for a few, is a source of income for a lot many. And the way they influence this market is huge. Let's say all those actual influencers who are selling products and they utilize these products, just like how you see ads in your normal television. Now, since the exact topography or demography of 16 to 34 is hooked to Instagram, they have to change their medium of advertisement as well. Now, what is an influencer agreement? An influencer agreement is between the two parties, the advertiser and the influencer. And in this case, the advertiser includes individual marketer, company campaign, or brand owner who uses an influencer to promote the sale of their products. Can you name famous celebrities who are influencers on? Yeah, famous celebrities, Indian, American. Are you guys on Instagram or not? Or like Instagram से कोई वास्ता नहीं तुम लोगों का? Huh? So Instagram celebrities, The Rock, very good prince. Love the example. He promotes his tequila brand. Okay. Priyanka Chopra. Okay. Prajakta Kohli. Okay. Very good. What about Jenners and what about Kardashians? Yeah. Kylie Jenner. Okay. Janila D'Souza. That's a great example. I love the content that both husband and wife make. Others, any example of influencer? Oh, that's a great example, both of you. Deepak, that's lovely. Sri also, yes. Okay. Shubham, okay. Yeah. Others example? No, you don't see international celebrities also? Okay. Yash Raj Mohate, Millie Bobby Brown. You, yeah. I can't even say Sri the name because I find it like a tongue twister. Also, of course, your football players, Ronaldo's, Messi's, everyone have their own teams who are doing a lot of this work. Any other example that you have of influencers? So you do get the hint as to how Kim Kardashian, of course, the biggest influencer that exists on Instagram. So this is to show that the power, that how products can be sold if you have, let's say, a lot of followers. That's why if you watch YouTube or if you watch Instagram, what is that one thing that all influencers are always selling you? LCS. What is the full form of LCS? Yes, influencer friends. What do you keep saying to everyone who was watching your video or your reel? Like, comment, share, subscribe. Very good. These are the most important words in the modern day transactions as such, because the business and the nature of things have changed. Influencer agreements have become the norm now. Let's go to the next slide. Essential clauses. Services to be provided by the influencer agreement, control over the content of the influencer, whether influencer may promote competitor products and services, ownership of intellectual property, access to influencers' data, brand reputation, advertising and regulatory compliance, and confidentiality and exclusivity. Going back to the tobacco example that I was giving you of the three celebrities we mentioned, which are the three celebrities? Who are the three celebrities, tobacco celebrities? You just name them. Yeah. Akshay Kumar, Ajay Devgan, and Shah Rukh Khan. Correct, Shri. Thank you. Exactly, everyone. Now, what happened when people wrote notices against Akshay Kumar and Amitabh Bachchan, for promoting these brands, they gave a very cryptic answer. They said, we have donated the money that we received for these advertisements, but as per the legal agreement, the companies will run this ad for the term period agreed. Did you notice that? When Akshay Kumar and Amitabh Bachchan gave this reply? That is to say that the control over the content exists with the brand. You might leave the brand today. You might tell them that this is the most fake brand, but the brand can still keep running ads of you if they have rights over this particular thing. And this is where exploitation happens. If you're a new celebrity, exploitation. If you're an old celebrity, you charge so much that it itself makes all senses. Next is whether influencer may promote competitor products. Sachin could not uh, like ever promote any other tire company except MRF, or whether it be uh, Dhoni. I think saying boost is the secret of my energy. Yeah, Byju's. Yeah, SRK. Now, when it comes to Coca-Cola companies, do you think there can be a competitor and non-compete clause where uh, Salman used to feature in Thumbs Up ad? Now I don't know who features. Shahrukh features in that ad, in Thumbs Up ad, because I think uh,
Ranveer.
Ranveer. Oh, Harika. Okay, correct. Mahesh Babu. Okay, so that Setmax has acquired rights to. Correct, Shubham. They have acquired those rights in perpetuity, I feel. Now, ownership of intellectual property. Influencers, for the limited time that they are showing that particular brand, whether by using it, by applying it, or by so on and so forth, for that particular time, they are just an assignee or a licensee for that particular time period. That does not mean the intellectual property vests with the influencer or the advertiser. Access to influencers data. This is very important. 50k follower, 100k follower, 1 million follower, 2.5 million follower, 100 million follower. They can access the reach of their particular advertisement. Why is reach important? If you have, let's say, 1 million subscriber reach, why is that important? Views. So if you have that much reach, if you have 1.5 million followers, that means these many people will be able to see the brand being promoted. That is why you earn money. That is why they keep saying like, comment, subscribe, share. Please get us followers. The more followers that they get, the more views they get, the more money they get. Influencers. When it comes to brand reputation, for example, there are many cases where like let's say someone says we utilize this product, and then on one of their social media accounts they find that this person is utilizing some other brand as such, and openly saying that that brand is like just because of advertisement purpose. They will be fired the next day, and their next payment schedule will never be uh, given, because of the reason that brand reputation is a huge thing. Advertising and regulatory compliance. You have to comply with the advertising standard code of India. That is to say, you can't sell tobacco, you can't sell alcohol also as influencers, or you can't sell products which are targeted towards infants. You can't promote all these profanity or explicits or nudity and so on and so forth. The ASI rules apply. Confidentiality and exclusivity is because they will give you that particular amount of data required for what you have to say and what is and how you have to sell it, and you are exclusive to their clientele, and therefore they will include a non-compete. These are 6 or 7 very important clauses in an influencer agreement. Next slide. Enforceability of an influencer agreement. Globally speaking, every influencer agreement has to comply with the consumer privacy law and agencies such as the CCPA, your GDPR rules, personal information protection and electronic documents, and the Advertising Standards Authority has also recommended the adherence to the consumer privacy law in order to be valid and enforceable. In India also, K. Puttuswamy protects your entire privacy aspect, as much as, like, your California Consumer Privacy Act and your GDPR regulation protects your consumer privacy. What happens is that you cannot sell the data of your followers. You can't say that, like, it will be another Cambridge Analytica. Now, what happens is, for example, if I want to know what is the demography or what is the age that is particularly subscribing to your products, if I get that, can I not sell this to some other company? Can I not sell, like, important data as to how many likes do you do of a particular object? Let's say if it's something to do with makeup, let's say there are some people who approve it, and when it is to do with clothes, then there are certain particular people who like it. Do you want this data, this like dislike thing that you do, to be known to brands? What would you say, guys, as lawyers? Would you prefer that? Or would you want your privacy to be protected? As consumers, we want our privacy to be protected, right? We don't want our data to be shared with any social media or any company for that matter, right? Or are you okay with that? For example, you follow Sachin Tendulkar. Okay, Sachin Tendulkar says that this is the best particular brand of cricket bat that you can utilize, and he gives the data for all those people who clicks on like. Is it breach of privacy? Yes. Everyone, are you following? This is easy of how you can't sell the privacy of your consumers as such. Influencers are bound by this as such. In India, it's a little shaky, but I've told you, Puttuswamy decision allows you to protect the same. Also, there are intermediary guidelines that have come as such, but they are still very shaky for enforceability purpose as such. So you can go to the court if you get to know that your data has been leaked, and that influencer will have to pay damages for leaking their data as such, and especially your personal sensitive data, or if you have like any such other things that you have of personal data, they have to comply with these guidelines. Okay, next slide. Prince, it's controversial. I can't answer this openly, but yeah, there are certain problems that are going with VPN right now. Can't openly tell you. Yeah, I'm prohibited to say on this platform actually. Any queries? Did you like it? The entire commercialization aspect as well as the influencer agreement? Yes, Mithun, you have a query?
Yes, sir. Is there any time limit for IP आपको IP, what do you call, registration? Is there any time limit that your product will be registered for 10 years, 20 years, something
The
like that?
fact, acha, after the death, for copyright it's 60 years. I think
Copyright,
trade,
yes.
there are limitations. For patent, I think India has 50, or for trademark there is 20 years. There are restrictions to that effect. There is nothing
Okay.
in perpetuity.
Till
So
that time I can claim. If I have that
your
rights.
family can also claim. Your family can also claim royalties. They
Okay.
can claim.
Because it's a property, it as asset.
Yes, up till
Okay.
whatever the term is agreed by the statute. That's why there are many people who believe in evergreening of their
Hmm.
IPRs. And I can't
Okay.
go into evergreening because that will be dark arts. But like, you can of course read on evergreening of IPRs, and you will find a lot of literature on that, Mithun. For
Okay.
example, after someone's death also, their family will keep getting royalties, and post the term of the statute they can get it evergreened also, like they can keep doing some additions and like just evergreen it.
Okay.
Yeah.
Thank you, sir. Thank you.
Okay, Sneha.
Hello, sir. Sir, previously we have discussed example of Zara for trademark. So I'm little confused here. If other person could register in different class with the same brand name Zara, if they can use it as their
Hmm.
trademark.
What
Sir, can
happens is, if there is no deceptive similarity that is created, and if it is not in ancillary products as such, like for example, if it's related to chemicals, Zara chemicals, if it is not affecting the image of Zara brand as such, you can go for it. That is the
oh,
whole deal. But if you go in any sort of accessories or any sort of clothing related marks, that's where you'll find the problem.
sir, there was a case with Louis Vuitton versus Louis Vuitton Duck. There was a restaurant in South Korea,
Hmm.
I guess. So,
Yeah, yeah. Now,
so they,
what happens is that people feel that this is a franchisee or this is a underling of that particular brand only. Now, this image you will say that like they're a handbag company. How can you get confused? But many times courts have established that there is a direct linkage between luxury orientation as such. It can be restaurants, it can be theme park, it can be resorts, it can be chocolates, anything, something that directly links you with that brand. And Louis Vuitton is something that is not a very uh, like common word to say. Like for example, if I say Anant, okay, my name, I trademark it and I protect it, but it is not unique only to me, right? There are many Anants, there are many people who are utilizing this brand, so then it becomes problematic. Louis Vuitton is a very well known trademark, so if they think that their business is getting affected, if the commercialization is getting affected, they can sue them.
okay, sir. So basically, we have to see beyond different classes also, like if it's
Yeah,
well known and okay,
if it affects, yeah, well known, and if it affects their commercialization process as such, and if there is an image created that they are linked to the main brand, that is when they go for passing off action.
okay, sir. Thank you.
Okay, Anshu.
Sir, I want to ask about the royalty. For
Hmm.
example, uh, who made a cartoon of Tom and Jerry, otherwise that Popeye.
Hmm.
Okay,
Hmm.
so you said there is a limitation on copyright, right?
Yeah,
Okay, after the death of who is maker of the Popeye or
let's say Mickey Mouse.
like a Mickey
If
Mouse, right? So their
hmm.
family members will get a royalty after the death.
Yeah,
At how much
yeah,
there may be much limitation, I think so.
the
Anshu,
statute, every
no, no,
country,
you can
Anshu,
go on.
there is a statute. Let's say US has their own law which says 50 years, death plus 50 years. So till 50 years, the entire family will receive benefits. Until unless what they do is they take out more movies of Mickey Mouse, more cartoons of Mickey Mouse. They take out more merchandising of this Mickey Mouse. Then it keeps increasing every year. Like
Okay.
let's say if they bring in a new comic of Mickey
And
Mouse,
after 50
then
years?
this is good. After 50 years, this is what I'm saying. This is evergreening. If I keep doing small things to increase the copyright age.
Okay, okay. Got it. Got it.
Yeah. Any other query? I hope you get to do influencer agreement or merchandising agreement once in your life, because they're very exciting as such, and that is why we wanted you to learn this also, Priyanka. And I had this thought process that you can really gain from this.
So
Any
I
other
shared
query?
a link if anyone wants to read about the copyrights or any IP rights related to Mickey Mouse. There's an article on IP leaders. So
Hmm.
back in 2021, it was my idea to introduce various aspects of IP through movies and the articles that we are using in day-to-day life. So this is one of them. You can have a look.
Lovely. Any other query, guys? Did you enjoy influencer agreement? All those who are influencers, please enforce your agreement in a better way and draft them in a better manner. All those lawyers, practicing lawyers who did this will become relevant very soon in Delhi and Bombay at least. And before you know, tier 2, tier 3 cities will have a bombardment of such agreements, because that's where the market is exactly, not tier 1 cities. Yeah. Okay. Lovely interacting with you guys. Have a great day.
Okay,
Thanks,
so
Priyanka.
we come to an end today for, the module on IP.
Hello, sir.
Yeah, so if you have any
I
doubts
think
pertaining to other classes as well, I would recommend that you ask them right now.
Shubham had a
Yeah,
query.
Hello, sir. Good evening.
Yeah,
yes,
Shubham.
Shubham.
So, like you used Mickey Mouse and Popeye images for the day, although they were totally for explanatory purposes. So, these are, I assume, must be exceptions of using this, or this does this also amount to copyright infringement?
One, this belongs to the exception. Second, also, what they have done is they have put the license terms. You can utilize Google Images if you use a certain license term as such. That this is not our copyrighted product, but we have licensed it under some open source agreement as such. You can utilize them till the time you don't claim it's yours.
Okay. Okay. Means we just have to give
Uh,
the credit to the respectful owners, right?
That's correct. That's correct.
Thank you. Got it.
Do we have
Hmm?
more doubts pertaining to other classes? Yes, Neha.
Yes, Neha.
This is from the previous class of the DMCA notice. So, in order to receive DMCA protection, registration of copyright is not required. So, how will the other party know that they are infringing someone's copyrighted work if it's not registered?
Once you get the notice, then you get to know that it is registered. That's how it works. There is a huge saying in IPR law: till the time you're not caught, you're not a thief.
Okay.
So it works, unfortunately, that way, Sneha. Rather sad, but yeah, that's how it works.
But I think that the
Okay.
third rule is whenever you're copying some material, you have to assume that it does not belong to you. The fact that you're copying it merely states that it's not yours. So I believe that any content that you find online, there exists an owner for the work, right?
Okay.
Yeah,
And
let's assume that it does. Hmm.
And
Hmm.
I have one more query. Whenever we use Google Images for some sort of, let's say, if I have to post on LinkedIn, if I'm using that Google image, so am I infringing someone's copyright work?
In one way, yes, you are. If you attributed this image is taken under so and so license term, so basically what happens is, even in Google Images, you have option of taking licenses as such. Okay, if you go there, you right click it, you do have the option of getting a license. You can. There are 2, 3 terms which they allow you to do so. But in strictest sense possible, in stricto sensu, yes, you are.
Okay. Because generally, people doesn't follow this sort of rule, like taking off license to post on social media.
Correct. And plus, how will the enforcement take place? Now, will they go visit each LinkedIn profile to take action against them? That also becomes difficult. So it's a little
Mhm.
problematic that way. But yes, it's a good practice if you don't.
Okay. Okay. Thank you.
Okay, there are some queries even in the chat box. Please give one more example of commercialization by assignment. Okay, now in this case, Kirti, what one can understand is that these agreements would exist because of the reason that you would not go into a certain country or a geographical market. So what you do is give an assignment to them, whether it be, let's say, of trademark, that okay, you are being a franchisee with us, so you get this assignment of trademark for your purpose as such, because you are getting everything under the franchisee agreement, so they can sign an assignment agreement as well. Let's say McDonald's can do that with you, or let's say, for example, if you are, let's say, Nali, okay, that famous sari brand, if they want to go and exert their influence even in United States or UK, They can enter into agreements with other Walmarts or Targets and all these, and give their trademark for the purpose of holding these goods in their particular stores as such. So assignment agreements exist that way as well. Next question that I have is, Harika, sir, as we discussed earlier in the influence and argument, at one point I heard that there should be no alcoholic beverages should be done, right? But I see some of the brand on beers get advertising. Is there a limitation for this? See, ASI really prohibits you to do that. Direct or indirect advertising is not allowed. But then I also see this of magic moments. I'm not promoting any brand, or neither am I saying that what is magic moments. But what I'm trying to tell you, Magic Moments does what is called as surrogate advertising. This is prohibited under ASCI. Yeah. Same is the case with all those mouth fresheners and sweet elaichi that they sell in the garb that they're selling tobacco products. So all this is prohibited
Also,
currently. Tobacco,
club
hmm?
sodas,
Yeah, music CDs also.
music CDs. Yeah.
Then Ayman says, then copying raising issues of plagiarism. This is the biggest problem now. It's bigger than cancer in this world, plagiarism. Turnitin is like the biggest cancer that exists in this world. Why? Because ultimately, it is said post 1980s, there is no new idea that has existed in the world. So if you are writing something new, chances are someone has already written that. So you have to attribute, you have to source, you have to cite, you have to footnote authors. Harika also says, and I also see some of the influencers openly tell that it is a paid promotion on Instagram. Yes, because of the fact that there was a huge debate that happened, that some influencers said this is the best brand possible, guys. Ultimately, European courts have come down very heavily on such influencers. They've said, no, you please, as a right to know, tell the consumers that this is a paid promotion, this is gifted, or this is somewhere you are earning money out of it. Do not do false pretense. That is why Indian influencers have also now, who want to show they're so authentic, they say it's paid, promoted, so on and so forth. Any other query? I think Priyanka.
Okay, great. So I think we can move on to discuss the exercise and the feedback of the last class. Dr. Anant, it has been a pleasure having you on board, and I guess we
Thank you.
will be inviting you once more for other lectures.
Thank you. It was a pleasure teaching you guys. I hope you learned something new about IPR, right?
Thank you.
Thank you, sir.
See you guys.
Okay, bye. All right, let's move on to discuss the exercise for today.
Madam, may I?
Yes, please.
Ma'am, actually, the last lecture I was not there due to some reason, and my LMS is not working from last many days. So I have requested them to open my LMS, but till yet it is not happening. So my assignments are also pending, ma'am.
No worries. So what you can do is, if you want, for the feedback of the last, when we discuss the feedback, you can exit the meeting, watch the recording once you have completed your exercise.
No, I am not getting any access of my LMS. This is a
Okay,
problem.
Anshu, I think we can discuss this at the end because this is a
Okay,
technical.
okay, fine, fine.
Ma'am, I have a request. I have exited due to personal reason the discussion of the last classes on the last three instances. But does this not challenge our credibility, ma'am?
Credibility pertaining to
In
what?
the sense that I haven't yet submitted the assignment, and somehow I feel that even if we do not, even when we leave, it leaves us that credibility issue from my teachers, and it could come that maybe I accessed the assignment in the last instance, and
No,
I
that's okay. That's completely all
I
right.
try to do the assignment as honestly as possible.
That's completely up to you.
Thank.
And I'm not giving out the answers. I'm discussing one assignment and I'm discussing it from a perspective what could be right or wrong. Even after that, you can still have your own things. I'll tell you something, these exercises are pertaining to drafting or stating your answers. There's no right or wrong. There are just varying degrees of how right you are or how wrong you are. So today we are going to assess Meeta's assignment. I've given her a 10 on 10 on one assignment. Does not mean that is the perfect answer. And if you choose to answer differently, you won't get a 10 on 10. Does that make sense?
Yes, ma'am. Thank you.
Great. Okay, so today's exercise is on character merchandise agreement and influencer agreement. The learning objective is very simple: to understand the concept of character merchandising and drafting of a character merchandising agreement and an influencer agreement. So the first exercise is on character merchandising. So I think all of us are acquainted with Doraemon. It's an animated series show that airs on Hangama TV, a children-oriented television channel. The main plot of this series revolves around the main character, a blue robot cat named Doraemon, who was sent from 22nd century by Nobita's great-grandson with the sole purpose of rejuvenating his life. That's the entire plot of this series. The show was an instant hit and has gained widespread popularity among children and adults. The characters of the show are distinctly recognizable and are loved by the fans. Seeing the popularity of characters, Animation International Limited, AIL, the owner of IP rights of the show, wants to cater to the hardcore fans by manufacturing and distributing merchandise related to the main characters of the show: Doraemon, Nobita, Sunio, Jian, and Shizuka. I don't know if you guys have kids in the house, you must be acquainted with all these characters. The merchandise includes live action figures, soft toys, key rings, mugs, and clothing. I think these are the most common forms of character merchandising. AIL has approached Bewakoof.com. Okay. Yeah, Bewakoof Private Limited, a well-known merchandise manufacturer in India, and for the said purposes, the parties have agreed to enter into a character merchandise agreement. After a thorough discussion among the legal terms of both the parties, they have arrived at the following terms. First is that AIL shall grant a non-exclusive license to Bewakoof for a period of 4 years to manufacture, market, and sell the products in India. The product manufactured should adhere to the quality standards prescribed by AIL in the agreement, and Bewakoof shall pay an advance non-refundable sum of 20 lakhs as against the royalties at the time of executing this agreement. Additionally, it shall also annually pay 40 lakhs as a minimum royalty. You see what's happening here, right? So accordingly, you have to draft the following clauses of the agreement. The first is licensed territory and channels of distribution, the percentage of compensation and payments clause, and draft an audit clause and a trademark protection clause. The hints to draft these clauses have been given in the exercise itself. Now we have the second exercise that is based on an influencer agreement. It is very simple. Laughing Riot Private Limited, an Indian comic content creating company, tied up with an advertising agency for marketing their content on the East Coast of the United States. While the advertising agency was able to employ different forms of marketing campaigns for the company, both the parties could not decide upon the right influencer needed for marketing their content on social media. So what happens is that the advertising agency could only offer a handful of influencer advertising plans. Laughing Riot fundamentally wanted an Indian American influencers to help them market their content. Laughing Riot's in-house marketing and outreach team came across a couple of Indian American artists and influencers who have been substantial following across US and UK. Probably they have 10 million followers. I don't know if 10 million is a very ambitious number. Probably they have a couple of million followers then. Before reaching out to them, Laughing Riot wants to understand how the influencer market works in the US and whether there are laws and regulations they should keep in mind before they enter into an agreement with some influencers for marketing their product. Now, considering this scenario, you have to draft the following clauses of the influence agreement. First is engagement and term clauses, ownership and IP rights, cancellation and termination, confidentiality and exclusivity clause, and payment terms. If we have any doubts regarding this exercise, we can clear them now, or we can move to the feedback of the last class. Any doubts? All right.
Any sample agreement will you provide us, or?
No, actually, you know what? The reason why I have stopped providing sample agreements is because you guys have started copy pasting from the samples that I've been providing. So it's very simple. Okay, based on the facts that have been enlisted, you just have to pick out those facts as you would draft a normal contract, any contract. So you know how to articulate your terms and clauses, right, of every contract, any contract, any legal document. You just have to articulate it in that manner and put it forward. So in this, you also have to think from the perspective of what everything that we have discussed in today's class. The slides will be shared, and whatever agreements that were discussed today in the class, they are hyperlinked in the slides. So only these are the samples that I'm going to share for now.
Okay, ma'am.
All right. So let us move to the exercise, the feedback for the last class. So the last class we had exercise on DMCA for takedown of copyright and infringing content, and where you had to draft a notice and a counter notice. But before you drafted a notice, there were following questions. So you had to brief Divya about DMCA notice and tell her what are the scenarios in which it can be used. So Smita has beautifully answered this question. She has stated that the DMCA takedown notice enables the complainant or nominated agent acting on behalf of the complainant to issue or host a service provider a formal notice of any copyright violation. This is perfect. That can be posted or uploaded on a website or any digital platform without proper authorization. This is perfect. So basically the intent is clear. The internet users from a WIPO member country can issue DMCA takedown for infringing work of a US based website server domain name without having without having to access the courts. This is also perfect. Though it is not necessary that the content or material should have a copyright registration, however, the complainant needs to ensure that the supposed infringement is in digital form, obviously, because the act itself mentions that it is digital millennium, right? So this is also perfect. So this is very well explained. And how will you set the DMCA process in motion? So to set the DMCA process in motion, the first thing is to gather the IP address, location, URL of the original content for accurate identification of the copyrighted work claimed to be infringed. This is perfect. The ISP address, location, URL of the infringed material for identification of infringing work. This is also perfect. Copies and print of screenshots of the original work posted originally. So this is the evidence that you will already be possessing. Print of the screenshots for the infringing sites and materials infringed on site. So not necessary that you have to print it. You can just maintain screenshots. You can also find the address of the registered website in case they don't respond to you. So just to keep it handy, basically. And she has drafted a DMCA notice takedown, which was a part of the question. So this is the how it has been addressed, which is okay. And to start with, she says that Divya is the exclusive owner of copyrights or distribution rights and graphic illustrations, including illustrations on Instagram page. And she has stated in this paragraph why they are receiving the notice. That is based on the facts that were given in the common question. This is perfect. And then she says that it's a serious offense that carries the risk of substantial monetary damages and in some case criminal prosecution. This is also articulated very well, although now you have mentioned that there are various equitable remedies available, but it will be better if this is solved amicably and in a manner that does not go in the court. This is also perfect. And after that, she has stated what are the actions, what are the steps that need to be taken by the service provider. So they require the subscriber to remove or delete all unauthorized copies of Divya property, ensure that the account is no longer used to copy, sell, or distribute the property in the future, and require the subscriber to confirm that the above steps have been taken. This is a very important point, that you must receive a confirmation that the above steps have been taken. So they can be in any format. They can provide you screenshots or any evidence will do. And take appropriate actions against the subscriber under your abuse policy or terms of service. This is perfect. The information included at the end of this notice specifies details of the infringement, including location that can help you and the subscriber prevent serious legal and other consequences of content theft. This is really good. Now, she has stated that the subscriber has a right to know whether their internet accounts are being used for content theft or they are otherwise unwittingly downloaded or distributing files that are subject to copyright protection, because that illegal activity could expose them to legal liability and other consequences under the terms of services and everything, that is mentioned in the terms of services. You've also mentioned the substantive law here, but it is not particularly necessary. You can mention it, but it's not particularly necessary. And she says that we appreciate your effort. So that's like a polite way of ending your letter, since the format is like a letter. And you have signed it off saying that this all has been done in good faith. And please be advised that this letter is and not intended to be complete statements of fact. This is also a very good approach. And there are also rights or remedies, legal or equitable, which are expressly reserved. So this is a perfect draft. And, you have also stated all this information of infringement. You've added a lot of this thing, what do you say, details to your evidentiary information. This is very good. It's a very strong attempt, I would say. Then you had to draft a counter notice to the same notice. This is also very well drafted. This letter is a formal response to claim of copyright infringement against the content that I've uploaded and published on printstock.com network. This communication to you is a DMCA counter notification. The specification of what this is very important under which provision of the law. This is also very important, and you have aptly mentioned. So in the next paragraph, you have mentioned what the complaint has provided, and this is the reply. Here the reply begins: without prejudice to the above, my use of the said material is legally protected because the complainant, the proprietor, has given all rights in her graphic illustrations available on the website to me via consent letter dated 15th May 2022. This is also perfect. Maybe you could have also stated that this has been attached in appendix or an exhibit. So that was also possible, but it's okay. You don't have to prove it unless you are asked to be proven. So that's also okay. So you have mentioned your arguments, and you've also stated later that the complainant disagrees that this is authorized use. They must work directly with me through legally viable channels. So basically, you are challenging the facts, I mean, the validity of the facts that the notice contains. So this is also good. And under no obligation to settle this dispute or to take any action to restrict my speech at the behest of the complainant. This is good. And I declare that under penalty of perjury, and I have good faith and belief that the complainant of copyright violation is based on mistaken information, misidentification of the material in question, or deliberate misreading of the law. This is also very good. I also understand that you will provide a copy of counter notification to the original complainant. This is really good how you have communicated with your intermediary and your service provider. and you have signed it off precisely. So this is a very good attempt. For your first exercise, I've given you a 9 on 10, and for the second exercise, I've given you a 10 on 10. So now if you have any doubts or anybody has any doubts, you can take them now. In the meanwhile, I'm going to stop recording.